Good morning, my lord. May it please this honorable court. My name is Muhammad Firdaus bin Razali, appearing as the counsel on behalf of the appellant Azlinda binti Ahmad. Appearing together with me is my learned co-counsel Muzdalifah binti Abdul Hanif. On behalf of the respondent, we have the learned counsel Ms. Khairunisa binti Khairuddin, and she will be assisted by her co-counsel Ms. Nuriza binti Muhammad Salim. My lord, we wish to put forward two arguments. I will be dealing with the first issue within 10 minutes, and the remaining submission will be dealt with my co-counsel for another 10 minutes. We will also reserve 5 minutes for rebuttal session. My lord, before I proceed, may the facts of the case be of existence to this honorable court. The appellant was the registered owner of a 5 million ringgit piece of land located in Melembu, Kota Kinabalu. Mr. Tony Leung Chi Wen, a registered real estate negotiator, was hired by the appellant to negotiate for the sale of his land to any potential buyer for 2.5 million ringgit. The appellant then handed the custody of the title of deed of the said property to Mr. Tony for safekeeping. Later, the appellant had discovered that the respondent had become the new registered owner of the land under a sale and purchase agreement executed on 12 February 2021. The appellant claimed that their signature in the sale and purchase agreement dated 12 February 2021, a power of attorney dated 19 March 2021, the memorandum of transfer dated 25 March 2021, and from PDS 15 were forged. Plus, the appellant also claimed that they were in the process of entering into a sale and purchase agreement with one Mr. Wong Chin Chai for the purchase of the said property for 3 million ringgit. The appellant also claimed that due to the execution of the sale and purchase agreement by the respondent, they had lost the value of their potential investor to sell the said property to Mr. Wong Chin Chai for 3 million ringgit. During the High Court trial, the appellant requested 4 remedies. Firstly, the appellants claimed the compensation of damages for the amount of 500,000 ringgit for loss of prospective investment. Second, the appellant insists that the land of transfer to the first to third respondent effected under the memorandum of transfer dated 25 March 2021 be set aside and cancelled on the grounds of forgery. Next, the appellant also claimed an order to the fourth defendant was the Assistant Collector of Land Revenue Kota Kinabalu to remove the registration of the transfer dated 25 March 2021 from the Central Land Office Register and Records. And lastly, the appellant also claimed a declaration that he is still the registered co-owner of the said property. The Learned High Court judge granted the appellant the second and third remedies on ground that the power of attorney used to transfer the land to the appellant to the respondent was forged. However, the High Court dismissed the claim for first and last prayer on the ground that the respondent were bona fide purchaser for value without notice, and they were declared as the new co-owner of the said property. The appellant appealed part of the High Court judgment, that is the first and the fourth prayer. The issue before the Court of Appeal are whether the appellants are entitled for damages for 500,000 ringgit, and the second one is whether bona fide purchaser for value and without notice obtain valid and indefeasible title to land immediately upon registration of the transfer. My lord, therefore I shall now proceed with my submission. There are 2 issues to be submitted before this honorable court. The first one, the trial court judge erred in law for not compensating damages to the appellant. Second one, the lead trial judge has erroneously decided that the respondent is a bona fide purchaser for value and without notice, obtain good and indivisible title to land immediately upon registration of the transfer, and is therefore an indivisible registered interest in land. My lord, I will be submitting on the first issue, and my co-counsel will be submitting on the subsequent issue. I will divide my first issue into 3 parts, which are: first, the sale and purchase agreement entered by the respondent was invalid. Second, the appellant suffered loss and damages as a result to forgery. and third, the appellant committed trespass over the appellant's land. My Lord, if there is no further question, may I proceed with the first issue? Much obliged. My Lord, for the first issue, we submit that the trial court judge erred in law for not compensating the damages to the appellant. My Lord, in order to prove that the trial court judge erred in law for not compensating damages to the appellant in this instance, on the first ground, we submit that the sale and purchase agreement entered by the respondent was invalid. Under Section 19, Subsection 1 of Contract Act 1950, any consent to agreement obtained by fraud is voidable contract. In other words, there was no consent given willingly, thus the appellant have the right to avoid the contract and render the contract not valid. Allow me to bring the attention of the court to the case of Sia Hong Ti and others, and Chong Su Kong and others, where the court held that the appellant's title or interest in the land was defeasible as it was obtained by forged instrument. Applying this principle to the current case, the respondent's title to the land is defeasible as it was also attained by means of forged instrument. The appellant should remain to be the valid owner of the land. My Lord, the second ground under this issue is we submit that the appellant suffered loss and damages as a result to forgery. In the case of Templeton and others and Lawyer Holding Sandalwood and another, the defendants were held liable for trespass and for the diminution for value of the land. The court granted damages to the plaintiff for the value of the land as if it were not injured by the act of the defendants. Referring to this case, the plaintiff demanded damages for the diminution of the land of the value of his land. He was amid entering a purchase and sale agreement that could profit him an additional 500,000 ringgit. However, because the land has been sold to respondent by means of frauds, the appellant lost 500,000 ringgit to prospective investment, indirectly result to the diminution in value of the land. My Lord, allow me to bring the attention of the court to the case of Datuk Jaginda Singh and others and Tara Rajaratnam, where the appellants obtained respondents' lands by means of frauds. The court then decided that to compensate the respondents' loss by giving damages. In the present case, the land was transferred to the respondent by means of frauds. It is absurd that the High Court did not give damages to the appellant. Thus, this appeal will enlighten the court that the appellant is entitled to damages. Another case that would help the court to understand the current scenario is the case of Plenitude Holding Sandalwood and Tansri Core Tech Port and another, where the court decided to grant the plaintiff damages for loss of profits on house development projects. In the present case, the appellant had also suffered lost profits of prospective investments. It is reasonable that the court grant damages to the appellant. In other words, as a result of forgery, the appellant suffered loss for prospective investment to sell his land to Mr. Wong Chin Chai. My Lord, the last ground for my submission concerning the first issue, we submit that the respondent committed trespass over the appellant's land. The trial court stated that the land was littered by the defendant's rubbish. Taking into consideration that the land belongs to the appellant, based on above arguments, the defendant's act is clearly an act of trespass to land. In the case of Terra Damansara Sandalwood and Nandas Development Sandalwood, the courts held that as long as defendants unlawfully enter and continue to remain on the appellant's land, and the defendants place an object on the appellant's land, the defendants would be liable under trespass. Under Section 166 of Sabah Law Ordinance, a trespasser to land can be fined not exceeding 1,000 ringgit or to imprisonment not more than 5 years or both penalty. Applying this principle to the present case, the respondent would be liable to trespass to land, looking at the fact that they littered rubbish in the land, thus establishing the element of trespass to land. By all means, the court should grant damages to the plaintiff for compensation of the defendant's acts of trespass. As such, my Lord, we submit that the trial court judge erred in law for not compensating damages to the appellant because the sale and purchase agreement entered by the respondent was invalid. Furthermore, the appellant had also suffered loss and damages as a result to forgery, and last but not least, the respondent committed trespass over the appellant's land. My lord, having finished with the first issue, does this honorable court need any further clarification before my co-counsel continue to submit on the next issue? Much obliged. If there is no further assistance favored by this honorable court, that should conclude my submission on the first issue. Thank you, my lord, for your time and indulgence.
My lord, may it please this honorable court, my name is Muzdalifah binti Abdul Hanif, appearing as the junior counsel on behalf of appellant. My lord, having finished with the first issue submitted by my co-counsel, I will be submitting on the second issue, which is the lien trial judge has erroneously decided that the respondent, who is a bona fide purchaser for value and without notice, obtained good and indefeasible title to land immediately upon registration of the transfer, and is therefore an indefeasible registered interest in land. My lord, it is our position that the trial judge has not erred in deciding that the appellants are still registered co-owner of the property. This issue will be submitted based on the three grounds, which by refers to the registration of the land was obtained by void and insufficient instrument by immediate purchaser. Secondly, no provision of indefeasible of title under Sabah Land Ordinance. And lastly, protection given to bona fide purchaser for value and without notice limited only where the purchaser is actually dealing with the proprietor whose name in the register. My lord, I would like to request 10 minutes of the court's time of my submission. If there is no further question needed by the bench, may I proceed with my submission? My lord, for the first ground comes within the preview of section 340, clause 2 and clause 3 of the National Land Code, where it provides that the transfer that had been obtained by an insufficient instrument, forgery or fraud remain defensible. The respondent's title or interest in the sale of land could be invalid since the registration of the land was obtained forged and insufficient instrument. However, the judgment of the current case applies the concept immediate indivisibility rather than deferred indivisible of title. I will highlight throughout my submission with the passage of Honorable Judge Gopal Sriram in the case of Bunsong Bunyanin against Adorna Properties, where the respondent's title can be defeated the said land if it can be shown that it was acquired by forgery or using forged and insufficient instrument. His Lordship stated that forged instrument is null and void and of no effect and not merely voidable, and therefore no right whosoever arise in favor of one who acquires title under a void instrument. My lord, further discussion can be seen in the case of Tan Yin Hong against Tan Sian San and others, that the court held that section 340 clause 3 of the National Land Code creates a deferred indivisibility concept and disapproved the principle of immediate indivisible that held in the case of Adorna Properties Sdn Bhd. By applying to the current case, the respondent's title of the land can be shown that the title or interest by respondent was obtained forgery and therefore should not obtain indivisible title as the respondent was immediate purchaser according to the decision by the High Court. My lord, for the second ground, there is no provision of indivisible title under Sabah Land Ordinance. This was referring to the judgment of Honorable Judge Igor Joseph in case Borneo Housing Mortgage Finance Berhad against Time Engineering Berhad, that the court stated that Sabah Land Ordinance is not an absolute torrent system of land registration. There is no provision in Sabah Land Ordinance conferring indivisible of title or no interest in land, which is crucial element of the torrent system of land registration. As well as the case above, there is nothing to Section 88 of the Sabah Land Ordinance to protect the interest of person who obtain title in good faith through insufficient and void instrument. Therefore, by applying to the current issue, the indivisible of title did not apply to the respondent as follows to the Sabah Land Ordinance that do not import the concept same with the National Land Code. For my last ground, the protection given to bona fide purchaser for value and without notice limited only where the purchaser is dealing with the proprietor whose name in the register. This was referring to the case of gifts against Messer that the court held that the protection which the statute gives to the person transacting on the fate of the registers is, by its term, limited to those who actually deal with and derive right from a proprietor whose name is upon register. Those who deal not with the registered proprietor but with a forger who uses his name do not transact on the fate of the register, and they cannot by registration of a forged deed acquire a valid title in their own person. Although the fact of their register will enable them to pass a valid right to third parties who purchase from them in good faith and for onerous consideration. By applying the fact of the current case, that the respondent who was intended to buy the land was dealing with the unknown forger, not with the real owner of the land whose name in the register. Eventually, the appellant discovered that the respondent had become the registered owners of the said land by virtue of a sale and purchase agreement that executed on 12 February 2021. My lord, if the respondent dealing with the proprietor whose name in the register, it will give safeguard to the title of bona fide purchaser. However, the respondent was not, and therefore less protection was given to the bona fide purchaser who was the respondent. My lord, I shall now conclude my submission regarding the contention on the part of appellant, whereby that the High Court judge error in law for not compensating the appellant 500,000 for damages suffered by the loss of prospective investment and damages for trespass to land by the defendant. And the respondent who is a bona fide purchaser for value and without notice should not obtain good and indivisible title to land immediately upon registration of the transfer. If there is no further assistance favored by this honorable court, that shall conclude my submission on the remaining issues. Thank you, my lord, for your time and indulgence.
Good morning, my lord. May it please this honorable court, my name is Khairunisa binti Khairuddin. Together with my learned junior counsel, Mrs. Nur Izzah binti Muhammad Salim, we represent the respondent, Mr. Megat bin Hasbullah and others. My learned junior and I have divided our submission in the same way as my learned friends opposite. I will therefore address my lord on the first ground of appeal, namely whether the appellants are entitled to damages for 500,000. Mrs. Nur Izzah will then deal with the second ground of appeal, namely whether bona fide purchasers for value and without notice obtain good and indivisible title to land immediately upon registration of the transfer and is therefore an indivisible registered interest in land. My lord, if there is no further question needed by the bench, may I proceed with the first issue? My lord, for the first issue, we submit that the appellants are not entitled to damages 500,000. On the first ground, we submit that only parties to the contract can sue the other parties. A person in the party only can press liabilities towards each other and claim the damages. Similarly, the parties in the contract cannot charge liabilities towards the third party because they are not a party to the contract. This principle is known as privity of contract. From the case of Treadle versus Atkinson, the court held that the claim by the groom was not accepted as the consideration did not come from him. He was not entitled to the contract even though it will give him benefits. As followed in the case of Keprong Prospecting Ltd versus Schmidt, the Privy Council upheld the said decision, saying that they did not refer to any provisions from Malaysian law. Thus, Section 2 Clause A, Clause B, Clause C, and Clause E of the Contracts Act 1950 agreed with the English law, saying that only the parties of the contract can sue. Section 2 Clause E of the Contracts Act 1950 stated that every promise makes consideration to each other is called an agreement. Considering when the respondent had signed the contract, it is a valid contract between the parties. Regarding the case of Dunlop versus Selfridge, the court held that the appellant cannot claim damages because they were not privy to the price maintenance agreement between the respondents and Dew & Co. Followed by the recent case in Malaysia, Lim Foo Yong and Sons Realty Sendirian Berhad versus Dato' Eric Taylor, the judges held that they could claim the damages because of the appellant's breach of contract. However, the one who wants to claim is the wife. Thus, the judges stated that she cannot claim for any loss because she was not a part of the contract. Based on the given facts, the appellants are not entitled to claim the damages of 500,000 because there is not privy to the contract where the appellants are not the direct parties to the respondents. Moreover, the respondents only made an agreement with Mr. Tony and the contract is only valid between them. My lord, the second ground under the issue is the respondents had no intention to commit the fraud. In this case, the appellants claimed that they argued that their signatures in the sale and purchase were forged. This has nothing to do with the respondents as they bought the land in a good faith. Section 17 Clause A, Clause B, Clause C, Clause D, and Clause E of the Contracts Act 1950 mention types of acts that can lead to fraud. It is either committed by one of the parties to the contract, or with his connivance, or by his agent, with the aim to deceive another party thereto, or his agent, or to persuade him to enter the contract. In the case of Loy Hian Chong versus Contact Shin, it stated that the act of the defrauder leads to fraud, not on the defrauded. As stated in the Section 17 Clause C of the Contracts Act 1950, a promise made without any intention of performing it will be called fraud. I shall now conclude my submission reassuring the contention on the part of respondent that the appellants are not entitled to damages 500,000. My lord, having finished with the first issue, does this honourable court need any further clarification before my junior counsel continue to submit on the next issue? If there is no further assistance favoured by this honourable court, that shall conclude my submission on the first issue. Thank you, my lord.
My lord, may I begin? Good morning, my lord. My name is Nurul Izzah binti Muhammad Salim, appearing as the junior counsel on behalf of respondent. My lord, having finished with the first issue submitted by my co-counsel, I will now move on to the second issue, which is bona fide purchaser for value and without notice may obtain good and indivisible title to the land. The issue will be submitted has two grounds, which are the appellant's title of the land can be defeated as the appellants are not the registered co-owner of the said property, and the validity of the concept of the immediate purchaser is still applicable in Malaysia's court. My lord, if there is no further question needed by the bench, may I proceed with my submission? My lord, for the second issue, we submit that bona fide purchasers for value and without notice may obtain good and indivisible title to the land. My lord, I will submit the issue based on the ground that the appellant's title can be defeated as the appellants are not the registered co-owner of the said property. If I may bring this court's attention to the relevant cases, that I will highlight throughout my submission. In the case of Borneo Housing Mortgage Finance Berhad against Time Engineering Berhad, the court said that the system of land tenure in Sabah is a modified torrent system and registration. Therefore, the appellants are not the registered co-owner of the said property because the respondents are the new registered owner of the said property that has been declared by the High Court. The discussion can be seen in the case of Sabindo Nusantara Serian Berhad. Judge held that even the indivisible title is not mentioned in the Sabah Land Ordinance, they recognize the registration land as a modified torrent system. Lloyd, we submit that Section 88 of the Sabah Land Ordinance can be interpreted as Section 340 of the National Land Code. For Sabah Land Ordinance and National Land Code still constitute the basic concept of torrent system, which emphasizes the importance of registration for the validity, title, claim to, or interest. As such, my lord, we submit that the respondents are the bona fide purchaser for value and without notice may obtain good and indivisible title to the land. Since the respondents are valid registered owner of the said property, and as in Sabah, it is valid for any person to purchase the said property to have a valid new title, claim to, or interest as they have registered the said property. My lord, having finished with the first ground of issue, does this honourable court need any further clarification? If there is no further assistance favored by this honourable court, then I will continue with the next ground of issue. My lord, I will submit the next ground of issue based on the validity of the concept of immediate purchaser is still applicable in Malaysia's court. Accordingly, in the case of Ardona Properties Sdn Berhad against Bonsum Bunyanit, the judges said that the plaintiff failed to prove beyond reasonable doubt that the seller's signature on a transfer memorandum was a forgery. The respected judge summarized that the defendant is still bona fide purchaser who purchased the land at true value and possessed indivisible title upon the registration. In other case, this view reiterated in the case of Tan Sri William Cheng Hengjem and others against Tan Sri Ngan Cheng Weng and others, held that the concept of immediate indivisibility is still accepted in Malaysia's court. The learned judge also highlighted in the case of ifs against if, in Lord Dennis' decision, state that it is good for the court to exercise the inherent power to prevent any unjust enrichment to the registered owner. My lord, in the present case, it is clear that the respondents are the registered owner of the land whom obtained the indivisible title because the respondents did not deal in any manners that inconsistent with the said property. As such, my lord, we submit that the validity of the concept of the immediate purchaser is still applicable in Malaysia's court. Because even the respondents are the immediate purchasers, the title is indivisible and the respondents did not aware about the forgery. My lord, having finished with the second ground of issue, does this honourable court need any further clarification? If there is no further assistance favored by this honourable court, I shall conclude my submission reaffirming the contention on the part of the respondents, whereby the respondents are bona fide purchasers for value and without notice may obtain good and indivisible title to the land. Thank you for your time and indulgence.
With the court's permission, I would like to reserve 2 minutes for rebuttal. Respondent made 2 points that I would like to address. The first one, the respondent stated that the appellants are not entitled to the damages on ground that the respondent has no intention to commit fraud. The respondent further cited the case of Datuk Jaginda Singh and explained the standard of proof for fraud. It is to my delight to state to the court that even though in the said case the fraud has already been proven, the court still gave the respondent in that case damages to compensate the loss he has suffered. This proved to the court that the element of fraud does not negate the right to claim damages. The second one, the respondent contends that even though the absence of terms indivisibility in Section 88 of Sabah Land Ordinance, it does not mean that it is distinguished from Section 340 National Land Code. However, I would like to clarify, even though with Section 340 National Land Code, the respondent still cannot obtain indivisibility as referring to the decision in the Tan Yin Hong case, that the court creates deferred indivisibility concept and disapprove the principle of immediate indivisibility that held in the Adorna property case, which by in other words it was overruled case. Therefore, even though referring to the Section 340 National Land Code, the title of immediate purchaser would remain defensible.
With the court's permission, I would like to reserve 5 minutes for rebuttal. In this case, the appellants made 2 points that I would like to address. First, the appellant stated that based on Dr. Jaginda Singh's case, the element of fraud did not negate the right to claim damages. In that case, the respondents get to claim their damages because the appellants were guilty of fraud, while in this case, the respondent did not fulfill any element of fraud as they had no idea about it. Therefore, the appellants cannot claim for damages as there is no elements of fraud in this case. Second, the appellant stated that the respondents are not entitled to get the indivisible title as stated in the Section 340 of the National Land Code. Referring to Tan Sri William Cheng Hanjam's case, the validity of the concept of the immediate purchaser is still applicable in Malaysia's court because the respondents purchased the said property with the good intention. Therefore, the appellant said that the respondents are not bona fide purchasers. However, we should not dilute the substance and functionality of Section 88 of the Sabah Land Ordinance that says registration is everything just because the word indivisible was not mentioned in the Section 88. Moreover, it will cause injustice to the respondents as the innocent purchasers if the court allows the returns of the land to the appellants. My lord, if there is no further questions by the bench, I shall conclude this rebuttal by the respondents, whereby the appellants are not entitled to get damages of 500,000 of Malaysian ringgits, and therefore, the respondents are the bona fide purchaser for value and without notice may obtain good and indivisible title of the said property. Thank you for your time and indulgence.